Greetings, blessings, and peace. This is Tex Masan from thctrust.org, and that is thctrust.org, not .com. And by the way, THC, for those who don't know, stands for the Heavenly Crown Trust. Anyways, before I get started in this brief video, I want to say thank you to Dr. Barati Bey from Maryland because he brought this information to my attention. And basically what we are going to show you and what he has found is that pursuant to the UCC Article 9 Section 203 that deals with parts of secured transactions, that the mortgage deed or your security deed or the deed of trust as some call it does not create an enforceable right to attach to real property or to foreclose on real property. And he has used this successfully in federal court and has caused the debt collector attorneys to withdraw their claim because they could not move any forward. They couldn't move forward. Now that is important. It's absolutely important. And others have used this too, as I'm finding out. Now, so we'll go into that. But let me tell you why that's important on one reason. Because whenever one files a claim in court, as you know, they have to have some type of contract from which the controversy arises. So typically what these debt collector attorneys do is they file in a mortgage deed and a deed of trust, trying to create the presumption that it gives them some type of authority to foreclose on your property. And that's just absolutely not true. And the bad part about it is they know it's not true, but they're depending on our ignorance. But we don't have to be ignorant anymore. So let me go ahead and get into this. But let me read this maxim first. It's called the doctrine of ultra vires. And it says, the doctrine of ultra vires is the most powerful weapon to keep private corporations within their legitimate spheres and to punish them for violations of their corporate charters. And it probably is not invoked too often. And that's Zinc Carbonate Company versus First National Bank. So what ultra vires, and I'm just paraphrasing in my own words. I encourage you to look it up. They do a good job of defining it on Wikipedia. But it's basically saying it's a maxim that we already really know. Corporations don't have rights. Everything that a corporation does, it must have the authority to do so by either a contract or some type of law or statute. So where we're going with this is, in these court proceedings, we need to ask, on what right are you attempting to foreclose on the collateral to the security deed? And that'll make sense as we get through this, because you're going to be able to see clearly that the mortgage deed does not create, let me put it like this. The elements that must occur for attachment and enforceability under the security instrument, which is the mortgage deed, has never taken place. And on that grounds, that security instrument does not grant a right to foreclose against the collateral named therein. So let me just go ahead and read here. And by the way, you can visit www.thctrust.org, create a free account, and log in. Because once you log in, then you'll see all the resources on the site, and you can download this PDF and read over it yourself until it sinks into your brain. This is a real simple thing, but we have to let these things sink in until you can understand it like second nature. I had to read over this thing about 3.5 hours so I can get it into the muscle memory of my brain, if you will. And now I got it, and I'm really excited about it, because this is probably one of the most powerful arguments you can make to stop a foreclosure cold. But again, a lot of it depends on, do you really know it, and can you express it fluently? For one, it's important to know that a lot of people may be sitting here saying that, making the argument that the bank has never lent money, and I'm bringing that up for a reason, because that's what a lot of this is all about. Certain requisites must occur for attachment and enforceability, and one is the the what am I trying to say? The mortgage deed does not appear to convey a lawful right to foreclose. While it may satisfy the requisites of a security interest by way of being a security agreement authenticated by a debtor, it does not in itself satisfy the requirements of attachment and enforceability in regard to the collateral named therein. The formal requisites for attachment and enforceability in a security interest require that value must be given to secure rights. The failure of the lender to give value prevented the security interest from attaching to the collateral, and therefore there is not an enforceable right against the debtor in regard to the debtor's property. And that's under UCC Article 9, Section 203B, Attachment and Enforceability of a Security Interest. So let me explain that again in my own words. What that's basically saying is, although your security agreement, which is your mortgage deed, may on its face be, it may represent a security interest. And really, if anything, and we're not even talking about all the fraud and all of that right now. We're just saying, let's just say that it was a valid mortgage deed. It represents a security interest, but the security interest is really in the account, right? And it does that just by being authenticated by the debtor, by being signed. But that does not in itself satisfy the requirements of attachment and enforceability, because under Article 9, which deals with secure transactions, it it tells specifically what must occur for a security agreement to properly attach to the collateral to give an enforceable right. And those requisites have not been made. And the main one is the lender never gave value. Now, I know that somebody's probably sitting here listening to this and saying, well, but if I go into court arguing that the bank never gave me a loan, that's not going to work. Well, let me put it like this. Sometimes that doesn't work for people because they don't really understand what they're talking about. And it becomes apparent that they're just going in there making regurgitated arguments that they don't understand. What you're going to find out is the bank is not even alleging that they did lend you any money. They kind of done so in the instrument, but they're not going into court saying we loaned you money. They know that. And if you're in there arguing it, you're really arguing by yourself, because it's kind of like already well known. But you know, so don't go in there trying to argue that it's just already known. You know what I'm saying? They know they didn't lend you any money, and as a matter of fact, a lot of times this is why a lot of the banks come in and try to allege to be the holder in possession. And the reason they're doing that is because they're inadvertently trying to avoid this requisite of UCC 9-203, that in order to have enforceability, that they had to give value to secure the right to the collateral. So they're trying to say that by some form of assignment or somewhere down the line, they came in proper possession. But you still have to know UCC 9 section 203 applies, because since attachment and enforcement has never occurred in the very beginning with the very first transaction under the security agreement, then those rights could have never been transferred. So it doesn't matter how many times it's been assigned, it doesn't matter who the holder in possession was, the right to have the attachment and the right to have an enforceable claim against the collateral could not have been transferred, because attachment never occurred under the original security agreement. So go download this document, read over it, and do so until it 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 gets into your mind till you can really understand it, because again, this is very powerful. And now, so here's another thing. Remember, the attorneys always, the first thing they do is they bring in that mortgage deed. So once you start asking the question, on on or by what authority are you attempting to foreclose on this collateral? Where is your contract? Where is your right? Where is your lien? right? That's what the doctrine of ultra vires says. It says you have went beyond your legal authority. And see, notice, they're real subtle with what they do. These attorneys, they file the mortgage deed in there and they don't say anything about it. They just file it in there, and they're doing it because they know the document, by the subversive use of language, already appears to give them a right, but they know it doesn't, so they don't say anything. They just file it in there, and they want you to go along with the presumption, so that when you challenge it, or I don't even really want to say challenge it, because they never say anything positively anyway. So once you put on the record that the security agreement does not create attachment or enforceability in regard to the collateral named inside of it, then you ask the question, by what authority are you trying to attach and foreclose on real property when you don't have a right to do so? Now you have the door wide open to come after these debt collector attorneys for fraud upon the court, because the mere act of coming in here trying to take property without a right to do so, and then even throwing in a document trying to perpetuate that it does in some kind of way convey a right, when clearly under Article 9, Section 203 of the Commercial Code it does not. Now you're trying to create a false representation, and you're being deceptive, and you're committing fraud upon the court. Look up fraud upon the court. That is exactly what they're doing. So on another note, we can't just start screaming these things out. We need to learn how to write valid civil complaints, and we need to formally charge them with fraud. Now, I'm telling you, when you do this the right way, they'll buck, because as soon as they file the claim to foreclose, they walk right into this, because they do not have a right under the mortgage deed, and they definitely don't have a right under a promissory note, and they definitely don't have a right under a grant deed, because that's saying your title. So the question is, they walk right into a fraudulent situation. I'm glad that we're finding this out. And there's also something else in here that I'm going to read. And this is along the same lines, because again, at the top we read the about the maxim of alter vires, which means you've exceeded your authority, right? Because now that you don't have a mortgage deed attaching to the collateral, which is now you don't have a contract, the question is, why are you trying to foreclose? And then let's read this law right here under the Uniform Commercial Code, Article 9, Section 102, that deals with a certificate of title. And by the way, the grant deed is a certificate of title. So I'm going to read through this. Certificate of title means a certificate of title with respect to which a statute provides for the security interest in question to be indicated on the certificate as a condition or result of the security interest obtaining priority over the rights of a lien creditor with respect to the collateral. Let me try to explain what that means from my understanding. The certificate of title, which is your grant deed, it requires that a security interest, that means if somebody has a claim against the collateral named in the certificate of title, that claim or that security interest must be recorded on the deed if their claim is going to take priority over the lien creditor, which is you. So that's basically saying, if you have a grant deed in your name, which you are the lien creditor of, which you always are, that means if somebody else has an interest in the collateral named therein, which is your property, then that interest must be recorded on the title. Now, of course, when we deal with houses, we don't have a certificate of title. We have what's called a grant deed. So when you read the second half of the code, it's saying the same thing, but it's only letting you know that it's applicable to the grant deed. So, and I'll read that part. It says, in this, we're talking about the term certificate of title. The term includes another record maintained as an alternative, and that's your grant deed, maintained as an alternative to a certificate of title by the governmental unit that issues certificates of title if a statute permits that the security interest in question, that means somebody else's claim over your property, to be indicated on the record as a condition or result of the security interest obtaining priority over the rights of a lien creditor, which is you, with respect to the collateral. So what this is saying again is if you have a grant deed, which you are the lien creditor of, and someone else is alleging to have a security interest in the property named in that title, then they must have a lien on the public record, and all these so-called mortgage companies do not have any liens on the public record. So what that is saying is, now that they don't have a valid deed of trust that gives them an enforceable right to attach to the collateral under the security deed, and they don't have a lien on your certificate of title, nor do they have a lien in the public record, then the question again is, by what authority are you trying to come in here and take my property? You don't have any type of law, you don't have any type of statute, you don't have any type of document, you don't have any type of lien recorded, you don't have any type of authority under the security agreement. You are perpetuating fraud on the court by filing these misleading documents in the court and trying to steal my property. That is what this is all coming down to. Now, I know somebody is out there probably saying, oh, but the mortgage deed is a form of a lien. No, it is not. And I'll tell you how I know that. Because I'm helping someone right now, and they ran a title examination on their house. And if you run a title examination on your certificate of title or on your grant deed, you're going to find the same thing. Although it may show a mortgage on there, remember, a mortgage does not attach. It's not an attachable claim against the collateral. But you will find, more importantly, a section under that title extraction that says judgments and liens, and more than likely under there you're going to find zero or none. So that means any form of assignment or mortgage on that title search is not a lien, because if it was, it would be listed under the section that says lien. So without a lien, they don't have the right to foreclose against your property. Doesn't mean they're still not going to try to come after you for the money or whatever, but hey, isn't that like a lot easier to deal with than worried about getting kicked out of your house? Hell, we can get things off of credit, right? We can discharge debts. That's easier than trying to keep them from kicking you out your house when they don't have a right to do so. But now we have some power and authority. One more thing that I have to mention with this is what we just read about certificate of title. Go in there and read that, because what this is also telling you is that if you are the owner of a grant deed, you need to be filing a UCC1 financing statement on that grant deed. And you may want to consider it as a non-UCC filing, because allegedly what's being taught now is that is the actual public record. But whether you do it, but on a certain extent, I think you really want to do it as a UCC filing, right? Because it is a financing statement, and you are basically saying that you are the lien creditor, because you are. You are the funder of the grant deed. You absolutely are. So again, it's basically saying if there is a lien, if there is a security interest on the title, it must be recorded. So this is some very powerful stuff to help you in your foreclosure issues. And again, this stuff has been effectively used to shut down a foreclosure, and I hope and believe it's going to work for you. Please visit www.thctrust.org, log in, or create your free account, log in, use our resources. If you have some very powerful information you want to share, send it to me, coaching@thctrust.org. And if you really want to help our organization, please join the premium subscription group for $16 a month. Thank you. I'm out.